Trump Trials and Presidential Election Daily Digest, February 2, 2024. Hello and welcome back to News Media Hant's Daily Digest. U.S. launches airstrikes in retaliation for drone attack on American soldiers. Question: will this development benefit President Biden against former President Trump? In response to a drone attack that claimed the lives of 3 American soldiers, the U.S. initiated airstrikes in Iraq and Syria targeting Iran's Islamic Revolutionary Guard Corps, IRGC, and affiliated groups. According to the U.S. Central Command, more than 85 targets associated with the IRGC's elite Quds Force and allied militias were struck, utilizing over 125 precision munitions against key facilities. President Biden emphasized, "Our response began today. It will continue at times and places of our choosing." The strikes aim to dismantle command centers, intelligence facilities, and logistics supply chains of militia groups and their IRGC sponsors involved in attacks against U.S. and coalition forces. Defense Secretary Lloyd Austin underscored the administration's commitment to curbing the capabilities of Iranian-backed groups, stating, "It was time to take away even more capability than we've taken in the past." The administration attributed the drone strike to the Islamic Resistance of Iraq, a group supported by Iran. While it remains unclear if Iran had prior knowledge of the attack, Austin emphasized that Iran sponsors, funds, and, in some instances, trains these groups on advanced conventional weapons. The retaliation comes after over 160 attacks by Iranian-backed groups on U.S. forces in Iraq and Syria since October, marking the first incident resulting in American casualties. SCOTUS showdown: Trump's eligibility tested in landmark election case. The Supreme Court will hear oral arguments on Thursday in what is shaping up to be the biggest election case since its ruling nearly 25 years ago in Bush v. Gore. Writes Amy Howe in the SCOTUS blog. The Supreme Court is poised to make a historic decision in Trump v. Anderson, a case that could determine whether former President Donald Trump, now a leading contender for the Republican nomination, can be excluded from the ballot due to his role in the January 6, 2021, Capitol attacks. With oral arguments scheduled on Thursday, this case has become the most significant election-related dispute since Bush v. Gore, nearly 25 years ago. The implications extend far beyond Colorado, where the case originated, as 11 other states grapple with challenges to Trump's eligibility. The crux of the matter lies in the interpretation of Section 3 of the 14th Amendment, enacted after the Civil War to disqualify those who had sworn allegiance to the Constitution but engaged in insurrection. Trump contends that this provision doesn't apply to the president, arguing that the presidency is not an office under the United States. However, challengers assert that Trump's actions on January 6 constituted insurrection, rendering him ineligible to hold public office. The dispute delves into constitutional nuances, with potential consequences echoing across multiple states and future elections. Ms. Howe states, although the question comes to the court in a case from Colorado, the impact of the court's ruling could be much more far-reaching. As the justices interrupt their winter recess to hear this pivotal case, the outcome could set a precedent for how Section 3 is applied in modern times. Trump warns of disenfranchising millions and predicts chaos if his exclusion sets a precedent, while challengers emphasize the need to uphold the rule of law, asserting that even a former president should be subject to constitutional scrutiny. The Supreme Court's decision may not only shape Trump's political future but also define the boundaries of constitutional eligibility for those seeking public office. Election trial delayed as higher courts weigh Trump's immunity claims. U.S. District Judge Tanya Chutkan has officially postponed the March 4 trial in the federal case against former President Donald Trump, citing ongoing appeals regarding his broad claim of immunity. Chutkan, who previously rejected Trump's claim of presidential immunity, stated that a new trial schedule would depend on the outcome of the pending dispute. The case involves 4 counts related to an alleged effort to overturn the 2020 presidential election. A panel of judges on the U.S. Court of Appeals for the District of Columbia Circuit is currently considering whether Trump can be prosecuted for actions during his presidency. The court will set a new schedule if and when the mandate is returned, Chutkan stated in the order. While Chutkan's decision was expected, it raises implications for Trump's legal battles in other jurisdictions. Special counsel Jack Smith is prosecuting Trump on 40 counts in federal court in South Florida, with a trial set for May 2024. Chutkan's ruling also paves the way for a state trial in New York, where Manhattan District Attorney Alvin Bragg has charged Trump with 34 felony counts. The charges involve an alleged plot to make hush money payments during the 2016 election, with the trial scheduled to begin in late March. Amidst these legal proceedings, Trump's advisors continue to seek further delays, emphasizing the absence of a new trial date in Chutkan's recent order. In addition to the federal case, Trump faces trials in other jurisdictions. Manhattan District Attorney Alvin Bragg is preparing to take Trump to trial in late March on charges of falsifying business records related to hush money payments. Trump's legal team perceives the hush money case as weaker and anticipates it will set a precedent for labeling the trials as politically motivated. Meanwhile, court proceedings in Florida around the handling of documents after Trump's presidency may impact the schedule for a trial set for late May. The Georgia state-level trial for Trump's 2020 election conspiracy has yet to receive a set date. Next, the latest on Donald Trump's criminal trials, Judge Chutkan, and DA Alvin Bragg. Keep watching to discover the latest on Fani Willis Fulton County controversy. Trump's first criminal trial, navigating the runts of legal checks. U.S. District Court Judge Tanya S. Chutkan's recent order canceling the planned March 4 trial for obstruction conspiracy charges related to the Capitol riot has shifted attention to the New York case over 2016 hush money payments, now likely to be Donald Trump's first criminal trial. While legal experts have often regarded this case as the weakest among the 4 criminal charges faced by the former president, the simplicity of the trial may prove advantageous. Ronald Kuby, a veteran criminal defense lawyer in New York, noted that unlike other cases, the New York trial avoids questions of presidential immunity, lengthy proceedings, and sprawling indictments. The charges in this business records case are linked to Trump's alleged misclassification of reimbursement payments to Michael Cohen, involving a $130,000 payment to adult film actress Stormy Daniels during the 2016 campaign. However, some legal analysts, such as Robert Mintz, a former federal prosecutor, consider the New York case a worst-case scenario for prosecutors, citing potential legal sufficiency challenges that could bolster Trump's defense claims of political motivation. Manhattan District Attorney Alvin Bragg accuses Trump of reimbursing Cohen for hush money payments, portraying them as legal fees. The charges include 34 counts of falsifying business records, with Bragg asserting the goal was to cover up violations of New York election law. Despite skepticism and criticism surrounding the case's timing and circumstances, Joshua Neftalis, a former federal prosecutor, suggests that the stakes are high, emphasizing the need to prove the case and allocate resources appropriately. The trial's focus on events more than 7 years ago brings unique challenges, but the prosecution aims to overcome them by emphasizing Trump's role in choosing Cohen as a key figure in the events. Complicating the legal landscape further, the judge overseeing the New York case has scheduled a critical hearing for February 15, potentially setting the trial schedule. As other cases, particularly the obstruction conspiracy charges in Washington, face delays and appeals, Trump's legal journey remains intricate. The uncertainties surrounding trial dates, appeals, and hearings in multiple jurisdictions underscore the complex legal web entangling the former president. Willis and Trump RICO case's top prosecutor acknowledge personal relationship. In a significant development, Fulton County District Attorney Fani Willis acknowledged a personal relationship with Special Prosecutor Nathan Wade in the ongoing Georgia election interference case involving former President Donald Trump. The admission comes as Trump and a co-defendant seek to disqualify them from the case, alleging a conflict of interest. Willis, in a detailed 176-page filing, dismissed the allegations, asserting that the personal relationship does not compromise their ability to handle the case impartially. The filing emphasizes that any personal relationship among members of the prosecution team does not amount to a disqualifying conflict of interest or otherwise harm a criminal defendant. The court document further challenges the claims made by Trump co-defendant Michael Roman, stating that his allegations are wildly speculative and lack supporting evidence. Willis and Wade contend that the relationship has not resulted in any direct or indirect financial benefits for Willis. Wade, in an affidavit, acknowledged the personal relationship but emphasized its development after his hiring, adding that they are both financially independent professionals. "We are both financially independent professionals. Expenses or personal travel were roughly divided equally between us. At times," Wade stated, "I have made and purchased travel for District Attorney Willis and myself from my personal funds. At other times District Attorney Willis has made and purchased travel for she and I from her personal funds. I have no financial interest in the outcome of the 2020 election interference case or in the conviction of any defendant," Wade wrote. To be absolutely clear, the personal relationship between Special Prosecutor Wade and District Attorney Willis has never involved direct or indirect financial benefit to District Attorney Willis, the filing states. As the controversy escalates, Trump responded on Truth Social, dismissing the case as a scam. Trump's attorney, Steve Sidow, criticized Willis' response, accusing her of asking the court to ignore alleged personal and financial misconduct. The defense argues that Willis's admission of the relationship lacks transparency and financial details. With the February 15 hearing looming, where Roman seeks to dismiss charges. The legal battle intensifies, raising questions about the impact on the credibility of the election interference case. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.